May I please, Lordship? Lordship, with respect to item number 13, 14, and 15.
Matter of which year?
Lordship,
You want
this is-
adjournment or?
No, Lordship, the rate appeals. Here, Lordship, the matter relating to state of Manipur, Lordship. Lordship, Supreme Court has passed the order, staying all the proceeding first. So I'm making on behalf of state of Manipur, Lordship.
Okay, these proceedings are stayed.
Yes, Lordship.
That's some service matter.
Yes, Lord, service with respect to appointment of managing director of corporation. Lordship. Next date is fixed on 18th October, August, Lordship. So it may be fixed on September.
Okay. So what do we do?
Lordship, it may be fixed after.
Let the item be called with passport.
Lots.
May I please, Lord?
Yes.
Lord, in respect of item number 8, Lord, we have filed, Lord, interlocutory application today. It is not on record, my Lord. Can it be, my Lord, day after tomorrow, my Lord?
We can adjourn it now. If you
Item
want
8.
some order, let the item be called. If you want any order beyond adjournment, let the item be called.
Now,
At
my Lord,
10:30, only adjournment.
my Lord, in addition to that, my Lord, item 17, my Lord, I have some personal difficulties, my Lord. Can it be, my
MU
Lord?
Mandal, 17 of which year? 23. Yes. MU Mandal petition adjourned.
May I please, your lordship?
Other one, ask somebody to make a mention, we'll pass that over.
May I please, your lordship? Lordship, in respect of item number 9, lordship, this matter has been wrongly listed before this honorable bench. So lordship,
How do you know it is wrongly listed?
so lordship, it is
No, no, how do you know it is wrongly listed?
so my lord is a bench.
How can a litigant take a call whether something is wrongly listed or rightly listed?
So probably I assume my lord is a
You cannot
bench for matter.
see on the top. Published under the authority of the Chief Justice. If the Chief Justice has given authority to publish this list, it is like that.
So I assume my lord,
I don't know your assumption.
yes.
Only the Chief Justice can tell if it is wrongly listed. No, you need to publish under.
Item 1 for motion.
How can it be wrongly listed? Ask the council to remain present. We will see what item number 9 is. Full matter, we would. Single bench or matter, maybe. Single bench matter. Wrongly listed. Why it is wrongly listed according to you?
So my lord, as per instruction of the engaged counsel, my lord, he has thus informed that their matter is pertains to land matter. And this is a civil bench for matter, so lordship.
You
Yeah.
check the list records. They don't on the prayer of Mr. Chaluk there. Case number bhul maybe.
Case number 1. This should be 2019.
Item number 9, 1133
Of 19.
19.
Okay, is it 18?
Okay. Okay, we'll pass the order. Let the item be called.
Obliged, my lord.
We'll see what is to be done. Let the item. If you make a different venture. Into
19.
this is showing somebody else's. Wait. You remain present, we'll do the next one.
Full register.
Item 1.
So any adjournment? 17.
Copy not provided. You got a copy?
Yes, lordship. Existence says I have provided.
So now we have to look at the records of Theok ME School,
Okay.
which is the school certificate, corresponding school certificate.
Page, connected to page 40.
Page 14. Page 14 is a prayer or something.
44.
0. And who is the father Pratul Das? Where is the voters list of Pratul Das?
No, sir, actually she produced the,
Some rehabilitation certificate.
and legacy data course she produced.
What is legacy data?
That is annex.
No, what is legacy data?
It should be the NRC authority.
Those have no evidentiary value. Now, who is the father? Where is the name of the father? Tell us that.
Should, that is at annexure 1, that is in the sale deed.
Page-
Father's name is reflected.
page number?
Lordship, at page number 28, Lordship.
28.
Lordship, this is Lordship,
Hmm.
and this one, actually this was, the petitioner provided the original certificate copy, but the,
Just a minute. You are relying on page number 28.
yes, Lordship. The vernacular is in page 30.
Paramesh Chandra Das
Jointly, they, Patil Chandra Das and his
and
brother.
Pratul Das.
Patil
They
Chandra Das.
purchased land in 1968. They are resident of village Tiok. Yes, what does the school register say?
Tiok Gaon, Bhoju, post office Bhoju.
No, no.
Lordship. Matching Lordship.
It is okay.
It's very clear.
Hmm. Hmm. Smriti Rani Das. Where is Smriti Rani Das?
Serial number 1,
136.
130. It was dead, Lordship.
Hmm.
Page is dead.
Oh. Yeah. Hmm. Hmm. So what do you do? But that could discharge the burden. Hmm. Because you are accepting it. This one doesn't looks to be an acceptable document. Equal to the- Yes, your name,
Lordship,
your name.
J. Paul.
J. Paul, heard MS J. Paul and counsel for the petitioner, also heard Mr. G. Sharma, Baki Indigo, as well as MS S. Kaul and counsel for the education department. The petitioner Smriti Rani Das had been referred to the foreigners terminal number. Where is the order of the terminal?
Page 46, Lordship.
46.
6. Connected to the-
Has been referred to the Foreigners Tribunal Tinsukia for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT case number 86/2009. The tribunal rendered an opinion dated 6/11/2019 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted in the writ proceeding. The petitioner relies upon a registered sale deed dated 29/3/1968, which shows that Pratul Chandra Das, son of
Wait,
the late
Prasanna Kumar Das.
Prasanna Kumar Das.
Prasanna, clear it out.
Yeah, please. Prasanna Kumar Das, resident of village Tiok in the present Sibsagar district, had purchased a plot of land at village Tiok, measuring about 8 bighas, 2 quarters, 5 lesses. In respect of Pata number 24, dag number 169. This one. By relying on the information contained in the registered sale deed, the photocopy of which is available on record. This is coming for the first time.
Let's do one more thing.
Record call kora nahi. Record call kora nahi. Next. Voter list not registered sale deed. Was a person who existed in the state of Assam at least on the sale deed, and as such, he cannot be said to be a foreigner. Further reliance is made on a school certificate available at page 40 to the writ petition, which is also exhibited as Exhibit C before the tribunal, which contains the information that Smriti Rani Das is the daughter of Pratul Chandra Das of village Tiok Gaon, and it studied at Tiok ME School. To verify the authenticity of the information contained in the school certificate, we required the Learning Council for the Education Department to produce the admission register in origin of Tiok ME School pertaining to the period when the petitioner had taken admission. The admission register in origin has been produced accordingly, and upon examination of it, it is noticed that at serial 132/83 of the admission register, that serial 133 of the admission register contains the information that Smriti Rani Das was admitted as a student who is the daughter of Pratul Chandra Das, resident of village Tiok Gaon. Accordingly, prima facie, the petitioner had discharged the burden under Section 9 of the Foreigners Act 1946 that she is a citizen. However, you have noticed that the matter notice is yet to that notice had not been issued in the matter, and accordingly, notice of motion returnable on short date that we could get 2 weeks one of date fixed to be issued. The records of the tribunal in FT case number 86/2009 from the Foreigners Tribunal Tinsukia be called for. A list on so and so for further consideration upon receipt of the records. In the interim, it will be list on so and so.
Obliged, Your Worship.
The admission register produced in admission register organ produced by MSS for is returned back.
Item 2.
Yeah, Madam Kaur, can you retain this one till the record comes so that we can? Please, can you keep it with you? Yes, sir.
Yeah, please.
My lord. Hey, return back to the council. Town is it 21 is all.
In this case, yesterday we have filed additional affidavit. Yeah.
Huh?
She can produce. Request.
But instead we have filed additional affidavit, Your Lordship. I think it is not in record, Your Lordship.
You want to call for it. List along with the additional affidavit filed by the petitioner
No, sir.
after a week.
3, 4, 5 for admission.
Maybe the lordships, I need some time, lordships.
Do it fast. We are waiting for this.
We already instructed, my lord, last Sunday also we are sitting, my lord.
Or otherwise we'll ask them to personally appear.
Lordship, my lord, there we are sitting, my lord, we are already been directed, my lord, the officers, my lord, to make it easy. Even as-
No, do it.
Lordship,
Mr. J. Handy, Land Council for Revenue Department, seeks for some further time for doing the needful of providing the list as indicated in the order dated. A 24/7/2023. Pray aloud list on so and so. It is expected that the requirement would be done and produced before the court before the next returnable date. Next. Pretty low. When do you want? Take a fixed date, but please comply.
next day,
Item 6.
Lordship, I will provide you. My lord, a report was for.
What report?
One in a police.
Report received, lordship, but I have not done to lordship.
Yes, Mr.
Report received, lordship, but I have not done to lordship.
17 August.
Same person.
Lordship.
Hmm?
Lordship,
Yes, now
But it-
you argue.
but inquiry. On the basis of an affidavit, lordship. Basis of inquiry and self-sworn affidavit.
No,
lordship.
no, this is what we are not very convinced with your SP. We can also call for an affidavit of the same man. We don't need the agency of an
Yes,
SP
lordship.
to get an affidavit. Why do you want the SP? To make a actual inquiry.
We are telling that.
Not the bill.
The superintendent of police border Hosea to remain personally present
Yes,
before the
Lord.
court on so and so. Next week.
Lordship, that will better.
But there is a further consultation with look at that is Gaungura. It was learned that alias so and so. We know that this person is calling himself as an alias. We want to only know whether he is the same person or different person.
Yes, Lord.
So we need the help of the SP.
Yes,
And what is the SP doing?
nothing. Lord.
We can also call for an affidavit of that man,
Yes, Lord.
where he'll say, I am alias so and so, it is over. Why we are not doing it? Why do we need the help of an agency called SP for getting an affidavit from that man? Go and make a local verification. Go to his house. Find out. If you find that they are the same person, tell us, oh yes, we went and found they are the same person. If not the same person, he is not the same person. Because he is making a claim that Kalamia of 1970 and Abdul Haq of 2005
Same.
of two different villages, they are the same person.
Hmm.
It may be right, it may be wrong.
Maybe wrong.
Both are equally possible.
Lord.
Let him come.
Yes, Lord.
I think he'll have to be educated a little.
Lordship.
Otherwise, this man, this is the second or third time
Yes,
we are calling
second-
for the
second time,
report.
Lordship. Yes, Lordship.
Who is he?
Lordship. Name is. I
Mhm.
don't know. Lordship. Ah.
Also, an affidavit dated 20 July 2005 has been produced. So he's SP is helping us in a judicial work or what? The court is unable to look and understand an affidavit of 2005. Let me look at it, give an interpretation and tell the court.
Lordship.
Is he substituting the court, your SP? List also, date it, I think.
Yes, ma'am.
Do you have any other material to show that these two persons are the same person?
A question.
No documentary evidence.
Hmm. Difficulty is both are equally possible.
Yes.
He may be, he may not be. But we have to give a judicial finding that he is. For that, we need a basis. Okay.
Okay.
The report dated 27/7/2023 is returned back to Mr. G. Sharma to be placed again before the court on the next return.
Item 7.
Made figure.
Civil authority. What is your argument?
No, my lord, I've just,
No, you have raised that argument
Yes.
on
yes, ma'am.
9/3/2023. Suppose we accept your argument, there will be a serious consequence.
Yes.
Because every reference is made by the SP.
Yes.
So all references made will be without jurisdiction, if I accept your argument.
Yes.
So if you are serious to argue it, please substantiate. Maybe you are right also, maybe you are wrong both.
Only thing, my lord, the Foreigners Act, as well as the Foreigners Order 1948.
Let
Mention-
us see, let us see.
Yes.
Because your argument is reference can be made only by a civil authority,
Civil authority,
not by police.
yes.
Okay.
And civil authority has been defined in the 1948 order. clause 5A of 1948 order.
1948 order. Yeah, Foreigners Tribunal Order 1948.
No, 1 year order 1948,
Foreigners
order 1948.
Order 1948. You have the same book. Which,
No,
which
different.
page?
Different,
Furnace
but
order.
5A is.
Ah, yes, sorry, yes, I got it. Hmm. 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 Seeks leave to enter India or depart therefrom or what is 5A?
5A is the civil authority may examine any person
Hmm.
who seeks leave to enter India.
Just a minute.
Oh.
Who seeks leave
Leave-
to enter India?
Yes.
Did the petitioner seek leave to
No,
enter India?
no.
Or to depart therefrom?
Yes.
Are you seeking to
No,
depart from India?
No,
If you want, we'll refer you to the civil authority.
No.
If you want to depart.
no,
No. Or during his stay in India for the purpose of her or any other matter and therefrom or during his stay in India.
yes,
So only when you want to enter India,
and depart therefrom.
depart. Does the petitioner seek to enter India or depart from India? Then 5A is not applicable.
Then what is applicable? There is no provision in the 1964 order
Hmm.
or in any other law
So when
empowering.
so where is the interpretation of law
Yes,
that if there is no provision, nothing can be done?
at least under some provisions of law,
Huh.
inquiry or investigation is to be made.
Hmm. Paragraph 97 of Muslim Mandal, read.
Only inquiry procedure mentioned there.
Inquiry is consequence also.
Yes, yes. But
See,
empowerment of inquiry is not there.
it is not required, it is understood. Some certain things are implied also.
Yes.
Number one. And number two, tell me what legal right will be violated. Suppose
Yes.
the law is silent and impliedly the respondents adopt a procedure,
Yes,
which is uniformly applicable to everybody.
yes.
It's not that only this petitioner
No.
picked and chose.
No.
Everybody, civil authority doing, only this man is, police is doing.
Yes,
Then you may have a case. In the absence of law,
yes,
there is a residuary power with the authorities
yes.
to lay down their procedure of their own or to adopt a procedure. Procedure may be implied, procedure may be expressed.
No procedure.
Implied.
Uh,
Implied.
Maybe.
And there is a provision for making an inquiry by the police. Reference is only the next step forward,
Yes,
which is provided in Foreigners
Yes.
Act 1964.
that I,
So,
The reference is
so that is good enough.
only inquiry.
Anyway,
Yes,
you are not challenging that procedure.
Yeah.
You are only relying on section 5A.
yes.
Section 5A is not applicable to you. We reject your contention.
If I am a foreigner,
Then you challenge the Foreigners Tribunal Order 1964. We'll hear you in an appropriate petition, not in this one.
I'm not telling.
Now, what is the case on merit?
Yes.
Tell us that.
On merits, my lord, the petitioner's own sister, report before depose.
Page number.
Uh,
Who is the father? First, tell us which
Yeah.
page.
Page number 23, my lord.
Page number
Judgment.
23.
Paragraph 3.
Page number 23. Page number 23 is the part of a judgment.
Yes,
We don't rely on judgment. Tell
There-
us by where the name of the father appears.
the procedure that is evidence of Moriam Nasa DW2.
Mr. Major Bhuya,
Yes,
the judgment in Pune is not an evidence before the court.
Right.
So show us the relevant evidence which will show who is the father.
evidence, the documents proved by the
Page number,
DW2.
page number.
In this petition, evidences are not there.
Then we dismiss the petition.
Yes.
You take your,
Only from the records.
no, we can't go on records. The writ petition has to be complete.
Evidence.
We
My lord,
close this petition, we'll give you to liberty to file a new writ petition with appropriate annexes. There's no other way out for you.
yes. Evidences are not there, other cards.
So why will not dismiss? Tell us.
My lord, it is there in the record.
It may be there in the record.
Yes.
Records were not before the court when the matter was issued notice. So it is a case where notice ought not to have been issued. We dismiss it.
My lord, I will be given at least 1 week's time to produce those documents.
Produce it.
Yes,
On list on so and so date, a fixed date, next week. To enable the petitioner to produce all relevant material that the petitioner intends to rely upon to discharge the burden under section 9 of the Foreign Act 1946. List on so and so.
Item 8.
Otherwise, it would be deemed that this repetition was admitted without relevant materials on record. Yes.
May I please, Your Worship? My lord, today we have filed an IA, my lord, for recall the order dated 12/6/23, my lord,
12/6/23.
23.
What is
My
that
lord,
order?
kindly adjourn the matter for the
Recorded a copy of this. What affidavit you have filed?
My lord, IA, my lord,
Why you have filed?
IA for recall the order 12/6/23, my lord.
Oh, why should we recall that order?
My lord, the order should be passed in WBC number 2434. But for bona fide mistake, it has been passed in WBC number 2101. my lord.
No, it is passed in 2434.
Passed in 2434, my lord.
Ah.
But it should be passed in 2101. 18, my lord.
We are not going to recall any order. That's quite a legitimate order requiring the admission registered in origin. We want to see it. That's all.
My lord, the matter may be taken tomorrow, day after tomorrow, my lord.
Why? That same matter, Mr. Mondal matter, MU Mondal,
My lord,
where he had wrongly got one matter closed by saying the wrong case number. That matter, I think. So now you see your mess. So why should we go on clearing the mess created by you yourself? Hitu matter court. Antu court 2-1. What's the other one? 2-1.
101.
We'll hear you both the matters together. Are you? Same writ petitioner had filed two writ petition. One is 2101, one is 2434. On the last occasion, you have wrongly got 2101 closed by accepting an order. Next day, when you ask you, firstly, you said, put the blame of the court, saying that it is the mistake of the court. When you ask you, court never passes any order on their own unless it comes from the learned counsel. Then you agree your mistake. Then you want this 2101 order to be recalled. We must have recalled, or it is yet to be recalled. Writ petition stands disposed of. So if at all you have to recall order dated 12/6/2003 in WBC 2101/2018. You have filed an IA for that purpose. IA to instrument, a list along with the interlocutory application filed by the petitioner in WPC 2101/2018 for recalling of the order dated 12/6/2023. This one.
Item 9.
Oh, 9/2.
Obviously.
Your repetition is 2019.
A good order, Malay.
We are not passing any order. It will go back to the registry.
Obliged, madam.
Item 10. Very deep.
Item 10.
Interlocutory. Huh? Dos Agosto.
Additional AG was supposed to have in this case.
Why? What is the issue
Regarding different approach.
of different tribunals?
Yes, my lord, this is with regard to the, my lord, related, one of the brother or sister has been declared foreigner and another has been declared citizen.
Hmm.
my lord.
No,
So in the-
You have to take which we get.
Two different approaches, I think by the same tribunal
Same
member,
tribunal. So,
But in this case, lordship,
it's by the different tribunal,
not same tribunal.
not
The member is different.
member is.
in that case, lordship.
What to do?
So what did, my lord, the issue was actually your lordship has called some judgments, your lordship has remembered. Your lordship has asked me to submit some judgments.
You
of
have
this-
submitted, but they are all orders which prima facie not sustainable in law.
Yes, madam. So the,
Why don't
Yes.
you file a writ petitions? We'll issue notice.
my lord, we are preparing it, we prepared some cases, my lord, that was due to some technical difficulties, that could not be filed, my lord. Now we are preparing some other cases, my lord, we'll file them.
The technical difficulty is over now, or it
No,
is
but
still exists.
Still, my lord, the only difficulty is that, but the state government, we are preparing the case.
Sorry.
State government is preferring, my lord, the appeal,
Huh.
the writ petitions.
Huh.
But the problem is that, my lord, whether the central government is a necessary party? Because central government is in that case.
Make
is
them,
the-
make them a respondent.
They would
I
just-
think the state through the Home Department is a respondent.
Yes, madam.
If you are aggrieved, if you have every right to file appeal.
Yes, madam.
If there is another co-respondent, normally what do you do?
Court.
Suppose in a suit, there are 5 defendants and 1 plaintiff. One of the defendant is aggrieved by a judgmental degree. What does he do? Does he not file appeal?
Pro forma respondent, we are. thinking
Does
to
he
make-
keep waiting because there are more defendants in that suit?
We are thinking to make them pro forma respondent, madam. So
Do,
that way
do,
we are preparing now. madam.
you know the law. Whatever is the law, you follow
No,
the law.
now we are thinking to do that, madam. So we are doing. So this matter will be taken along with this matter.
Adjourn on the prayer of the respondents to be listed again.
Item 11.
And the lordship, but in this case, status report was got forward.
But not, this. Hey,
Order.
This is sent for FSL. So my learned.
A communication dated 19/7/2023 from the Subarnapur Police Border Kachar has been produced to the court. A perusal of the communication gives the indication that some further time would be required for the purpose of the investigation. Time, a list after 2 weeks for an update of the status, updated status report of the investigation. The communication dated returned back. Investigation.
It can be kept there, my lord. We have spoken.
No, it's a
Yes, yes,
something while
Yes,
the
yes.
investigation is going on, we
Yes,
should
yes.
not keep it in,
yes, that will do.
take it back. Because anybody may have access of that.
Yes,
one
madam.
once it is. Fine, Mr. Paing, want a fixed date or a?
Any date, my lord, as your lordship may please. If it, if.
Item
if it
12.
is After 2 weeks, my lord, because after 3 months.
Vice Versa.
Lordship,
28 August. 28.
Marginal.
may I please?
Item
Report.
12, yes.
Yes, Lordship, may I please, your Lordship, Lordship, in this case, I have filed an additional affidavit.
Some report.
Report also was there, called for
Uh-huh.
from, by the respondent authorities. Report from the respondent authorities.
Mr. Paing raises a doubt on the authenticity of Home Department may make an inquiry.
Yes. My lord, I have not received the report. Let it come after 1 week.
Adjourn on the prayer, Mr. G. Paing
Lordship,
and Home
I have
Department.
filed twice, this is the second time they are taking time, Lordship. I had filed one additional affidavit. Where I intend,
We'll take note of your additional affidavit, definitely.
yes, Lordship.
But once there is a judicial order, he
Yes,
wants to
Lordship,
make
I
an
know.
inquiry.
Yes,
That we
Lordship.
can't stop him from.
Yes, Lordship.
Six for an
Next,
adjournment for providing the report of the inquiry as indicated in the order dated 14/6/2023.
yes, Lordship.
Rest after, Iman,
One
Mr.
week
Pai.
time.
After 2 weeks, my lord.
So 1 week he said, Lordship, maybe a date may be fixed, Lordship.
Item 13 to 15.
A copy of the order of the Honorable Supreme Court dated so and so has been produced before the court. Dated the month in a special leave to appeal, C number so and so has been produced. Proceeding stands adjourned. Or I think we have already completed the, or it was an interim order.
It was an interim order.
That was an interim order, or it's,
Lordship, it was. That.
okay. And accordingly, further proceedings shall remain strict. A copy of the order kept on record.
Much. Okay.
Is it here for you? Mr. We adjourn for how long?
Lordship, case are fixed on 18th of August before the.
No, now the,
It may be second week of September,
as the next date has been fixed by the Honorable Supreme Court on
18/8.
18/8, list immediately thereafter.
Much. Okay.
Item 16. Vice Versa.
Lord, in this case, the education department for the district limited education officer, the original admission register of the petitioner was directed to be produced.
Lordship.
This item number 12 and 16, they are same person or different person?
12
Goes could go.
and 16.
This item number 12 and 16, are they the same person or different person?
Oh, it's a different person. This is of Walpara, mine is of Kamrup district.
But both are margin.
Margin, similar name, Lord. Lordship.
Yes. Interim because,
Lordship, in this matter, I need some time to protest.
MSB Dekha Education Department seeks for some further time to provide the original admission register as required by the order of 14/6/2023.
Interim may kindly,
List after 2 weeks.
interim may kindly continue.
You want it to be continued?
Yeah.
Do you want it to be continued?
Miller,
Your name, please.
A. Ali Miller.
On the prayer of Mr. A. Ali, Land Council Petitioner, the earlier interim order to continue till the next returnable date. This continues.
Item 18.
Tell him, just explain him. Yes.
Like your lordship, my lord, your lordship is called for the LCR, my lord, LCR has come.
LCR has come.
Yes, my lord, one record was also called for, my lord.
What record?
My lord, the marriage register, my lord.
Marriage register. Marriage register available, Mr. Sharma? Did you?
One of them maybe,
By the order dated 14/6/2023, the marriage register in original of the maintained by the Kazi Bilasipara pertaining to the period when the marriage is stated to have been solemnized on 10/1/1995 was required to be produced. It is stated that the marriage register is not available. The Superintendent of Police border Dhubri to do the needful to make the marriage register available.
19.
To Mr. G. Sharma.
18 is it?
16 to be acceptable.
19. None appears for the petitioner when the matter is called. List again. In the event of subsequent non-appearance, appropriate order shall follow.
Item 52 for hearing.
In this matter, on last occasion, I have produced the instruction, your lordship, of the petitioner.
Complete voter required by have been produced on the zone to enable to examine the same. Where is Mr. Pine? Did he examine?
Name is already there, your lordship. The petitioner's name is Khalilur Rahman. your
No, no, he
lordship.
wanted to
Yes,
examine.
lordship.
Where is he gone?
No, they are not saying. About this one.
Yes.
I've examined my lord on this matter.
What did you find?
It's my lord, what my learned friend is saying.
Mr. Ali is saying that their complete voters list required by the order 31/5, 31/5.
Hazipara.
Hazipara.
He claims
So
to
the, yes, you please argue your matter. Please argue your matter. Who is the father?
Page 17, lordship.
17 or 70? 17.
17. 1965 voter list. lordship.
Rustom Ali, grandfather.
no, no.
Muslim is the, no, Muslim is the father.
Yes, lordship.
Muslim son of Ruson,
Yes.
1966, Hazipara. Now,
Next, lordship, page 19, lordship.
page number.
Page 19, 19.
No, you don't go serially, you have to go serially. You tell us.
In
Full
1970.
Khatun is the mother.
Yes, lordship. Mother adduced evidence, lordship.
Mother had adduced evidence. Where is the evidence of the mother?
Page 40, lordship.
Page 40.
40.
40.
Last.
Yes, Mr. Pine, what do you say? What is para 5? page 41.
Younger son.
What is para 5?
The petitioner,
Please read.
that the real fact is that my younger.
Just a minute. Do you have any unreal fact also? Do you have? No. Fact is a fact. How can it be a real fact and unreal fact? Yes, Mr. Pine, what do you say?
My lord, mother has abuse evidence.
Huh.
Full Khatun's name is there in the 1970s.
70 full Khatun is there. Age is also more or less same. 1970, now 77 in 2017. Not only it's exactly same.
Yes.
After 47 years, she is 77 years now. Muslim had died in the meantime. Which year did Muslim die? Their names are continuously appearing. Mr. Ali has vouched for it that up to 2016.
Yes.
Only thing you can look, Mr. Pai, whether the person who appeared before the tribunal is actually Full Khatun or
Some other is.
somebody else. That is the only thing you can verify.
Then your lordship may remand back for verification of that part.
And also consider the evidence. No, it will solve over it. You can demand the Aadhaar card of Full Khatun and compare whether the
Yes.
person before the tribunal is actually Full Khatun or somebody different.
Yeah.
Heard MSP Ghosh, Land Counsel for the petitioner, also had recorded. The petitioner Khalilur Rahman had been. Is there the name of Khalilur Rahman along with Full Khatun
Yes,
in
yes.
any of the voters
Yes,
list?
lordship.
29.
Page
Huh?
25.
The instruction I have provided, your lordship.
Ah.
Page 9 in voter list of 1989.
89, they appear together,
Yes, sir.
same village.
Same village, Hazipara.
Khalilur Rahman had been referred to the Foreigners Tribunal. Number 1, Borpeta, for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of FT case number 485/11. Tribunal rendered an opinion dated 9/5/2018. 9/5/2018. Declaring the petitioner to be a foreigner, being aggrieved this writ petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1966 of village Hazipara police station, Borpeta, in the present Borpeta district, which contains the name of Muslim son of Rusan at serial 62. It is claimed that Muslim son of Rusan is the father of the petitioner. The 1970 voters list of village Hazipara contains the name of Muslim son of Rusan at serial 81 and that of Full Khatun, wife of Muslim, at serial 84. The age of Full Khatun is claimed to be the mother and her age is noticed to be 29 years. Full Khatun had rendered evidence before the tribunal as DW2, presenting herself to be Full Khatun, wife of late Muslim resident of village Hazipara and aged about 76 years. In her evidence, DW2 had deposed that the petitioner Khalilur Rahman is her son. Full stop. To verify the matter further, we required the Election Commission to produce a complete voters list of village Hajipur from the years 1966 up to 2016. And accordingly, all such voters lists have been produced before the court. Upon examination, it is noticed that in the voters list of 1989 onwards, the name of Khalilur Rahman appears along with that of Full Khatun in respect of village Hajipur. And both are shown to be residing in the same house.
Even Muslim Uddin name also appear in the same house in 89.
In 1989, voters list, the name of Muslim Uddin also appeared along with Full Khatun and Khalilur Rahman, and all three were shown to be residing in the same house. The aforesaid materials gives a prima facie indication that the petitioner may have discharged the burden under section 9 of the Foreigners Act, that he is not a foreigner. The only aspect that remains is whether the person who had deposed before the tribunal as DW2 by stating her name to be Phul Khatun is actually the Phul Khatun of the voters list of 1970 onwards in respect of village Phul Khatun, wife of Muslim of village Hajipara, or some other person may have presented herself before the tribunal as Phul Khatun. The tribunal may examine the said aspect by requiring the DW2 to produce the Aadhaar card for its examination. In the view of the matter, remanded back, the tribunal, upon considering all the voters, complete voters list of village Hajipara from 1966 onwards up to 2016. More particularly, the voters list of 1989 containing the name of Muslimuddin, son of Rusian, Phul Khatun, wife of Muslim, and Khalilur, son of Muslim, as well as the evidence of DW2 and past region audit. The complete voters list produced by the Election Commission is returned back, but however, a copy thereof may be provided to the Learned Council, photocopy thereof, Learned Council for further presentation before the petitioner is Ramja Ali.
Yes, Ramjan Ali, but he was made debuter, therefore, he has some problem to not unable to produce certificate copy of the voter list, but Jamabandi copy is there, my lord. Jamabandi lot fine. Page 68 vernacular.
Page number
Page 68, my lord, vernacular.
68.
Ramjan Ali, father's name at top, Moinuddin. Then second time also Moinuddin.
What is this? Circle officer.
Yes, sir. And his name is at serial number 7. There are 2 orders of the family.
This is not very legible, Mr. Sigzar. This photocopy, do you have a better copy with you?
My lord,
Not readable.
Yes, sir.
my lord,
এখনো হে একই নয় ফাটি ফাটি যায় যে অক্ষরটি। No, with great difficulty you can interpret what it may mean, but difficult to read straight away. Yes, suppose it is right. What is your submission? When did Moise die?
my lord, in his deposition, he said that 14 years back, 14 months ago, father died.
Means around.
My lord, in his, my lord, deposition, my lord.
Hmm.
DW1.
So around the year 2016. 16, 15. So, yes,
Better copy, Didi, when you take number.
Ramjan Ali.
Ramzan হলে নামটো কেই নম্বৰ আছে 7 নম্বৰ
Number 7, it appears to be Ramjan Ali, son of Moizuddin. Hmm.
চক্রবিধার 20 আর 2018 তারিখের নামজারি
2020-8-2018, no, last one.
মানে ফার্স্ট ওয়ান
Yes, what do you say?
তাগর মাটির উত্তরাধিকারী সূত্রে মইজুদ্দিন শেখর স্থলত মজিরন নেসা then my lord Idris Ali
Mr. Sikdar, you are reading or you are saying it by heart? Because this is the same language used by in every order of a mutation.
yes ma'am.
So are you reading or you know the language and therefore
I'm
you are able to spell it out?
Get eligible copy of this certificate.
Sorry,
Eligible copy of this মানে
no, it is
because
eligible, he will produce before the
Yes,
tribunal.
sir. We'll give a better copy.
reference basis of institution.
But prima facie, it is there.
আৰু invitation to 2011.
Send back.
2018.
Mr. A.R. Sikdar and counsel for the petitioner also. 16 of the will be 18 থেকে আছে। You will now 22 years before now we were actually questioning that why you were going for mutation. Also heard Mr. Paine Sharma.
Let's support.
He is showing Mr. Sharma, Sharma is saying Mr. Paine.
Let's support.
Is senior lordship.
The petitioner Ramjan Ali was referred to the Foreigners Tribunal number 5 Borpeta for rendering opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of case number FT 340/2016. Tribunal rendered an opinion dated 13/3/2020 declaring the petitioner to be a foreigner. Being aggrieved, the state petition is instituted in the writ proceeding. Reliance is placed upon the voters list of 1966 of village Poschim Moyon.
Moinpuri.
Guri is not written there. Or Poschim Moyon.
My lord, voter list, my lord.
No, I am reading page number 34. Guri is not there. Only Moyon is there.
Lordship may kindly have a look at my lord in the 70 voter list. 70 voter list.
Poschimali
Yes,
police station Bagbor. Don't question. Can police station Bagbor in the present Porpeta district, which contains the name of Moyez Sheikh, son of
Mahmoud Ali.
Mahmoud Ali, at serial 641, and that of Moziran Nessa, wife of Moyez, at serial 642. It is claimed that Moyez Sheikh is the father and Moziran Nessa is the mother. The name of Moyez Sheikh also appears in the voters list of 1960, but in 1970 of village Poschim Moyanguri. But in the later voter list of 1997, his name appears as Moizuddin's son of Mahmud. It is claimed that Moyez and Moizuddin are the same person, and it is only a variance in the name depicted in the voters list. Petitioner also relies upon a jamabandi of a plot of land at village Moyanguri. Moyanguri, which contains an order of the circle officer dated 28/2016 in mutation case number BAR/KAL/2018-19/281 FMUT, by which, amongst others, name had been mutated in favor of Rustam Ali, son of Moizuddin, in place of Moizuddin, and accordingly, the Jamabandi had also been corrected by incorporating the name of Rustam Ali at serial 7.
Ramjan Ali.
Yes, Ramzan Ali at serial 7. Upon a query, it is clarified that Moise, father of the petitioner, died in sometime in the year 2016. And accordingly, after his death, mutation took place in the year 2018. In view of remanded back to examine the voters 1966, 70, and 97, as well as the information contained in the Jamabandi in respect of the plot of land at village. Yes, the village Moinguri. The petitioner to produce the complete voters list of village Moinguri from the year 1966 up to 1997 for examination of the tribunal. Want to say something?
Also, Moez and Moezuddin are same person or no?
The tribunal to also examine as to whether Moez of the 1966 and 70 voters list and Moezuddin of the 1977 voters list are one and the same person. The respondents in the Home Department may make their verification and submit report before the tribunal upon doing the needful. Reason for that.
Moez Sheikh of 1966 voter list. And
Moez Sheikh.
Yes, my lord, we are going to file an additional that we have filed and here, my lord. Father's name and mother's name is in the 60 total list, but you can find at least 14. Ramizuddin is the father,
He is 14.
is 14.
Forest Salbagan.
Shalpara.
Ramizuddin is the father. Lahizan stepmother.
Father hyphen Nessa is the stepfather.
Lahizan is the stepmother. Last time you said stepmother.
Reason.
And Haiton Nessa own mother.
Yes.
This is what you said when he heard you last time. Lahizan, yes, Haiton,
Louisan is the stepmother. In para 8 of the
Lahizan stepmother, that's what we are saying. And Haiton is the
own mother.
own mother. This is what you said last time.
That is also the.
Very well. Now, Riazuddin, which material show Riazuddin is the son of?
I have the number of mother documents to link with father and mother. He is an army staff, an army person.
That will not make him a citizen.
And the mother, there is a certificate issued by the additional district magistrate, lodging find at least 20.
Mr. Sikdar, you choose your best document.
Yes,
Because difficulty is if you produce more documents,
Correct.
Mr. Pahing will point out the conflict in the various documents and he will say that none of the documents are to be
I'm
taken.
relying on this.
So you rely on your best document.
The domicile certificate.
Page
issued
number
by the Page 21 is.
20,
fact copy.
21.
Page 20. Fact copy, original photocopy is 20. This is the certificate that the Mohammed Asai is the son of.
Oh,
Village. Albagan.
Page number 20, you want to rely.
21 is the fact copy, 22 is the photocopy. And this was the requirement while he was getting employment ballot. And his service certificate, my lord, and it's a.
No. Service certificate will not make you a
Well,
citizen.
This.
In fact,
certificate-
service certificate will make you a more dangerous person. Suppose you are not a citizen, but you entered the Indian army.
Well,
they draw up a court martial against you now. So service, don't rely on the service. Produce on the rudimentary documents which will show your citizenship.
This is the domicile certificate issued with the additional description.
Domicile certificate is it issued after any verification? Yes, additional deputy commissioner who represents? You represent additional deputy commissioner. Can your certificate be relied upon? What kind of inquiry you had made before issuing this certificate? See, these are specialized proceedings where the citizenship of a person is determined. While issuing the domicile certificate, did you conduct any inquiry in this nature?
Okay, without inquiry, it cannot be.
We don't want presumptions, nor we want any what the learned council is thinking about. Suppose we call for the records, will the inquiry come?
What's it? In this
See,
regard,
Today you can say
yes.
without the food being cooked, it is not possible for the food to be placed in the dining table. Definitely. But the question will remain whether you had cooked the food or somebody else had cooked the food. No doubt in that submission that without cooking, food cannot be in the dining table.
Lordship, in this regard, instruction is required, Lordship.
Because he is relying upon the contents. So if we accept these contents and say that he is son of Ramizuddin, then he is definitely discharged. But Mr. Sikdar, why don't you rely on your other document?
School certificate is there, birth certificate there, but
Where is the birth certificate?
my lord, birth certificate, my lord,
Page number
is 18.
18. Why don't you rely on your birth certificate? Birth certificate, we have already delivered the judgment. No? It is very easy. Rupa Das. No?
Birth certificate.
Birth certificate, we have already delivered the judgment that it is admissible in evidence.
Problem is, my lord, he born on in the year 1981. And this certificate has been issued of 2020. 2002.
Mr. Sikdar, why do you create your own problem? When the law does not create problem for you, why do you create your own problem? Are we aware of the law relating to birth certificate?
Birth certificate, my lord, if within the year, no problem, but after 1 year, there will be a registered order.
Where do you get that?
My lord, is the date and birth registration act, my lord, 1969. There is.
Okay, this date of registration is 5/6.
Yes.
Yes.
There is delayed registration.
Yes, what to do? Let us call for a school register. If you that will be very acceptable. As the petitioner also relies upon the school certificate issued by the page 20, issued by the Kothal Tali High School. To rely upon the information contained therein that Muhammad Riazuddin is the son of Muhammad Ramizuddin of village Salbagan, Tangia. The admission registered in origin of the said school pertaining to the period when the petitioner was admitted to the school be produced before the court. A copy of the order be made available to MS B. Dekal and Counsel for the Education Department. Yes,
My
Counsel.
submission is that, my lord, I want to rely on the domicile certificate issued by the district register.
But we have to call for the records.
That may be.
Whether domiciles, but this is the easy way out for you. If the school certificate, it is acceptable,
Then, my lord,
we'll complete the proceeding. You don't have to rely on anything else.
my lord. Problem is, my lord, the school are not maintaining the records properly. That is the problem. my lord.
Okay.
The schools are not recording the documents properly.
Please take it.
We have also noticed that the additional deputy commissioner had issued a domicile certificate to the petitioner dated domicile page 20 maybe 22. They
25/8/2000.
25/8/2000,
Lords.
which contains the information that Muhammad Riazuddin is the son of Ramizuddin of village Salbagan, Tangia. The additional deputy commissioner Nogao to produce the records based upon which the said domicile certificate was issued. Sorry, list on so and so for both the records.
Yes. Much of that.
Item 56 for orders.
Sorry. Some mistake.
একটু নাকি জমির হোসেন না কিংবা রিপোর্ট আনি দিছিল নাকি ইনকোয়ারি গুলো লিখে আছে
Yes, page 9, what is the mistake? Para. G. Sharma. This interlocutory application is instituted for correcting the order dated 25/5/2023 in WPC 9197/2019. That in the second paragraph, it should be Superintendent of Police Border Morigao and not Superintendent of Police Border Nogao. Correction allowed. The order dated so and so be read that the direction for verification is to the Superintendent of Police Border Morigao and not Nogao. I allow as indicated.
Item 2251 for hearing.
I know, we are aware of it. Sorry. Display board is always about half a minute slower than the court proceeding. Because display board button is clicked only after the matter is called, not before the matter is called. So you can never have the correct information. So what do you want today? We passed the order, none appears, adjourn, list again. In the event of subsequent non-appearance, adverse order shall follow. That is the order we passed. You want it to be changed. But the file is already gone out. Goal, no?
File good.
I have to change code. Adjourn on the prayer of yeah. Instead of none appears, we are making it adjourn on your prayer. This next week.
2251.
Well, in these matters, before my respected senior friend starts, in respect of item number 20, that is the Arunachal matter, your lordship might have noticed that on none of the occasions the petitioners have been present. Perhaps they might have lost interest. One of the reasons might be that entry 52 itself has been deleted. There is no longer any entry tax. That might be one of the reasons. And in any case, the act itself is completely different. The provisions are different. So this item may be perhaps be segregated. And if they are not pursuing it,
Segregated is difficult.
if they are not,
Once integrated, segregated, we need a reason. See,
the acts are completely different.
maybe after hearing the thing, if none appears,
It is likely to be.
we may dismiss for non-prosecution also. Ultimately, what else to do?
Because on none of the dates, I have
Understand.
seen anyone from the petitioners.
And
They were,
If
they
you,
perhaps might have lost interest.
you can ask some of your colleague to remain present, or if you want.
Because on some of the
And
dates,
they-
I might have to be in Itanagar. I thought that,
You take note of that. You ask somebody to
My
remain
lord, my
present, number one, and number two. If persistently no one appears and comes forward, we pass the orders in the others, and this one will dismiss for non-prosecution. What
Ma-
else to do?
my lord, that is what I was trying to point out to your lordship. In that case, my lord, intermittently, your lordship will excuse my presence, man. Deeply obliged.
লাগিব ডাঙৰ যে কাগজের যে লিখিয়েছিল
Malab, your lordship may first may not see the section 3 once again.
section
3 of the act.
this the one
My lord.
this the
So the question was that, my lord, the lordship raised that whether section 3(2) is exemption or not. Section 3(2) is provided for that notwithstanding anything contained in so and so. Whether it amounts to exemption. Now, your lordship, can you see, my lord?
just
Well,
this is vis-a-vis paragraph radius maybe. That particular paragraph in there. Perhaps we ask this question,
144, my lord.
144.
My lord.
We are inclined to accept the submission that so long as the intention behind grant of exemption and adjustment is to equalize the fall in fiscal burden. So grant of exemption, adjustment, credit.
Okay, sir.
So on this basis, we
Your
ask
lordship
you,
has
so vis-a-vis
In fact, I prepared one dictionary meaning of exemption from all the corpus, stouts, everything.
No, no, I understand. X is after V, na? E. Exemption. huh. Freedom from duty, liability, or other requirement. Duty, not this excise duty, this duty. Duty is there is a requirement to do something. Liability, there is a requirement to pay something or other requirement. So the basic thing is requirement. Freedom from that requirement.
I'm just trying to get.
Huh. So exemption presupposes the existence of a requirement. Now, when no levy is made, there is no requirement.
I put it.
So this is what we are trying to understand, that when there is no levy, whether it will be an exemption or it will be a case of no levy simpliciter.
Well, I'm just trying to satisfy, try to make submissions on that only.
Huh.
Well, under the Entry Tax Act,
Hmm.
the taxable event is entry of the goods.
Huh.
Once the entry is there into the local area, the goods becomes
No,
taxable.
no, I understand. Suppose we don't go by these acts and all, they are too complicated. We go by a simple model.
Minor.
Moment the goods enter Srirampur, there is a liability to pay tax. Suppose the tax law is straightforward to that extent. Now, if the goods are red in color, you will not have to pay the tax. Say for goods X, there's a requirement to pay the tax. But for some reason, if the goods are green, yellow, and blue, you have to pay the tax. If it is red in color, you don't have to. This will be an exception, because otherwise you are liable to pay. But if the color of the goods you are bringing is red, you are exempted. So requirement is there, followed by a non-requirement. And that non-requirement is the exception. Going by this example, if you read section 3(2), notwithstanding anything contained in anyone. So moment it is notwithstanding, it's a non-obstant clause. You just have to shut your eyes to everything else, including the provision which imposes a requirement. By shutting your eyes to everything else, what it provides? No entry tax. That means if this particular condition is satisfied, what is provided in 3(2), there is no tax. When there is no tax, there is no requirement. And when there is no requirement, there is no exception. And when there is no exception, how you relate with para 114?
Try to.
Basically,
I got it.
this is what we are trying to
You
do.
also may kindly see. For the time being, section 3(1).
Hmm.
Subject to other provisions of this act, there shall be levied and collected an anti-tax on the entry of the specified goods into local area for consumption, use, or sale therein. So even if the goods are imported for the purpose of sale, anti-tax is
Entry
levied.
tax is there.
Now, I am bringing the goods for resale.
Dr. Saraf, what you are going to say, we have already,
I am,
what you are trying to say, we have already foreseen it, that this is the,
so Milord.
so your submission will be 3-1 brings in the requirement. Moment requirement is there, 3-2 will be an exception.
I'm just further.
I think this is the principle. huh.
Because I'm little slow, Milord, in that way, Milord. Your lordship.
No, we are also not fast.
Milord, when the goods are coming,
Hmm.
then if the goods are imported for the purpose of consumption, use or sale, irrespective of fact whether they are consumed, whether they are used, whether they are sold, anti-tax will be leviable.
Yes.
Now,
Should we become a little more faster?
my lord,
Should we become a little more faster? No, you said.
now, I bring the goods
Hmm.
for the purpose of sale.
Hmm.
I don't sell it, keep it for 6 months. Anti-tax I have to pay. After 6 months, I make the sale
And it comes under the VAT.
and it is in VAT and I make the sale and I'm liable to pay the VAT. At that stage, it is on the happening of a subsequent event. A specified event must take place
Understand?
after the taxable event has taken place.
Hmm.
So if the taxable event has taken place, it has become liable
Understand?
and subsequently by any provision, it says that you are not liable.
Under 3-1. Liability to pay
My lord,
entry tax is
on the
imposed.
happening of the taxable event.
It's imposed. In other words, happening of
Taxable event,
taxable event.
that is entry of the goods.
And later, if the
Subsequent events,
if the goods is subjected to the VAT by
goods which are subjected to VAT
goods are subjected to VAT,
are sold
VAT upon being sold, which is a subsequent event. Event, comma,
and
so therefore it will be an exception.
Because there are 3 conditions below which have to be fulfilled.
Mm.
The dealer must be a registered dealer under the VAT Act.
No, Dr. Saraf, that's why I said.
He must be
Dr.
selling.
Saraf, that's why I asked you, should I get even faster?
No, my lord, I have the way.
No. Yeah, it's a good, interesting debate.
So these.
And the questions we are asking doesn't mean we are against you. We are only trying
In fact, because your
to
lordship asked me a question,
find out.
because your lordship asked me a question, my lord. I have the opportunity to again go through the sections. Otherwise, I would not have gone to this provision itself.
Perhaps this argument would have been readily acceptable straight away without any further question. Had section 3(2) started with the word provided. So provided means it presupposes the requirement or existence of a requirement which is before that particular provision, and an exception is carved out when it is provided. But difficulty is the word notwithstanding.
Well, notwithstanding also
Huh.
take care of it.
So moment it is the word notwithstanding. Notwithstanding is a non-obstant clause which will obliterate all other provisions in the same statute, as if the provision thereafter, the non-obstant clause is the only provision that is existing,
Well,
meaning thereby no levy on a goods which had entered the state and is subjected to VAT. So
with due respect.
So-
Well, by the-
the model that you are presenting is when the goods is entering the state, it is indeterminable whether it will be sold or it will be used. This element of determinable becomes only when
Goods
that-
are sold.
goods are sold, which is a subsequent event. This is the model you are presenting.
Further, much I will submit, my lord,
Understand?
that notwithstanding.
Understand. Now, how do you interpret the expression notwithstanding? This is what we are now required to explain, required to explore now.
Well, notwithstanding, in my humble submission, my lord, it means whatever might have been stated in other provisions, irrespective of what has been stated in the earlier provision. That irrespective of whatever has been stated in subsection 1. Now, that doesn't mean that one has gone, it is not obliterated. It says that though in one, the liability is there, but if these things happens, then they will not be liable to pay tax. As you also seen 302 and 3 and 4 million of constitution. 3 said that only parliament can make a give preference or put restrictions in case of scarcity. 304 said notwithstanding anything contained in subsection 3, article 303, state can impose the tax. Meaning thereby, though 303 states that parliament can only do so, but under these conditions, state can impose the taxes. Now 303 has not gone. 303 remains. But out of 303, it says irrespective of the
have you bought any judgment how notwithstanding is to be interpreted?
But I was thinking that your lordship, it will take time, but so fast your lordship proceeded on 303, 1 and 2. That I thought that next day the notwithstanding question will come. But today itself the question of
See.
notwithstanding is coming.
It is not that notwithstanding anything contained in this act, We have to take. It is notwithstanding anything contained in subsection 1, meaning thereby all other provisions are
Intact.
intact. But the levy of tax is under 3.1.
My lord.
Had it been under section 2, you would have had a nice escape route.
My lord.
Because say levy of tax had been under 2, so levy is there. But notwithstanding difficulty is notwithstanding 3.1. 3.1 is the section by which this requirement is brought in.
Now, 3.2, my lord. It says that under these conditions, you will not be liable to pay tax.
No, see, it's a no entry tax shall be
Say he
levied.
levied, so he will not be liable. Now, first of all, he must be liable, then only he will not be liable.
If such specified goods are brought into any local area by a dealer registered under VAT.
Now, just a minute. If
So the element of the subsequent event proposition that you are propounding, that possibly is ruled out because if such specified goods are brought into any local area by a dealer, so brought into, this will be at the time when the goods are brought into the state.
My lord,
Who will bring in by a dealer registered under the VAT? What is the purpose? For resale. So this is not a subsequent event. Subsequent,
yeah, my lord.
the event takes place when the goods are entering the state.
No, my lord, your lordship, just a minute.
We'll
It
come
says-
back.
It said, "Lord, if specified goods are brought into local area for a registered dealer under Assam Value Tax Act for the purpose of resale, up to that,
No, the actual resale may take place. It's a subsequent event. But the act of being brought into any local area, this is number one, by a dealer registered under VAT for the purpose, then no tax.
no,
Then what will happen? No entry tax shall be levied.
my lord, if I am bringing the goods for resale,
And not only to this thing, subject to production of documentary proof.
my lord,
So why I am trying to just ask you on this question of subsequent event, because 5 elements has to be satisfied at the time when it comes in. It is subject to production of documentary proof. 2, it has to be, goods has to be brought in by a registered dealer. 3, for the purpose of resale. All these happenings will be determined at the time of entering.
no, my lord, with due respect, my lord.
So,
The subsequent, my lord, lordship, see,
No.
and such goods are sold inside the state,
Huh.
and the dealer is liable to pay tax on the same,
so
so and so.
So when the registered dealer produces documentary proof at the time of entering the state that I am a dealer, this is for the purpose of resale, no tax will be levied.
No, my lord, with due respect.
Now, under the law, no tax. I'm
No.
not saying the physical levy,
No, my lord,
no tax will be levied.
no.
But
due respect to
he
your
will
lordship,
also have to satisfy a later condition that and such goods are sold.
my lord, with due
Suppose he gives all kind of declaration that it is for resale and makes it a case of no tax levied, but later on consumes the whole goods himself. Then this section will take, the later part will take where such goods are sold.
With due respect, my lord,
Dr. Saraf, you don't enjoy your lunch.
my lord,
You don't you enjoy your lunch?
no, nowadays better not to enjoy the lunch. Because some weight will go down, my lord.
Sorry,
Some weight will go down.
what will happen to us?
Well, your lordship needs lunch, but we don't need the lunch. Your lordship may enjoy the lunch. At 2 o'clock, my lord.
We'll come back at 2 o'clock. You don't take lunch.
Normally avoid the. With your liberty, I may just, from my side, what I.
No, no, you are good because we should not be.
No, no, no,
this
from my
thing.
side, what I understood,
Hmm,
that I may explain to you.
hmm.
Well, if you read the section 2,
Hmm,
then it says, notwithstanding anything contained in section 1 and subject to the production of documentary proof,
hmm.
no anti-tax shall be levied on such specified goods which are also taxable under Assam Value Tax Act so and so. If such specified goods are brought into a local area by a dealer registered Assam Value Tax for the purpose of resale and
Such goods are sold.
sold inside the state,
Hmm,
and the dealer is liable to pay tax on the sales of such specific goods.
hmm.
So, the condition which is there is that the goods must be liable to tax under Assam VAT Act. The goods are imported from outside for the purpose of sale, resale. The goods are sold within the state, and the dealer becomes liable to pay tax on the same. And in respect of this fact, that he has sold the goods inside the state and he has become liable to pay tax, he must give the documentary proof. Otherwise, what will happen? I bring the goods because I am bringing the goods for consumption, for use, for sale. Now, when the goods are entering into Assam, at that time, there is no provision that whether I will for resale or whether what you will use or consume, that is not so. Once the goods enters into the local area, and the same are for the purpose of consumption, use or sale therein, anti-tax becomes levied. Now, I'm asking question myself. That I bring the goods for the purpose of this sale, and I don't make a sale. It remains like for 6 months,
Hmm.
the goods are remaining as it is. I have to file monthly returns for anti-tax. Now, whether I can say that these goods which I bought for resale, I'll make sales subsequently in future. And since I'm going to make this resale, and I will be liable to pay VAT, anti-tax shall not be levied. In my respective submission, no. The exemption, in so many words, will be available only when he makes the resale of the same goods into the local area and he becomes liable to pay tax. And the documentary proof which has to give is with regard to making of resale and liability of payment of the VAT. Otherwise, my lord, there is no provision at the entry gate, my lord, when the goods are entering, one has to only show, one has to only determine whether the goods have been bought for the purpose of use, consumption, or sale. Now, if the goods
Dr. Saraf,
My lord.
if I have understood your argument correctly, the liability to pay the entry tax will take place moment the good enters the local area. This goods can be used for the purpose of resale, it can be used for own consumption, it can be used for any other purpose, any other use. After the goods enter, if the event of resale takes place, at that stage, the necessary documentary proof will be shown. Say, this is my payment of VAT, this is my thing, I have this resale. So I should be exempted from the liability that took place when the goods entered. Liability under section 3(1) when the goods entered the local area. This is your, I think, the sum and substance of your argument.
I am obliged, my lord, in 2 sentences, your lordship has summarized what I was trying to argue for 1 hour. This is exactly my submission for lordship. I'm just submitting.
Our,
My lord.
let me
My lord, my lord.
see, Dr. Saraf, difficulty is what you know. You are presenting on behalf of the dealers. So your thinking will be a little at a variance from our thinking. If I present a matter from the dealers, maybe I would also say the same thing. Our concern is we are called upon to decide the validity of a statute. One of the fundamental principles of adjudicating the challenge of a statute is, firstly, there is a presumption on the validity of the statute.
Absolutely.
Secondly, it's a duty of the court at first instance to save the statute.
Absolutely.
Only when it is not possible to save the statute, third option is for interference. So we'll have to look at the whole thing from the 3 corners of these 3
There is
principles.
no doubt about it, but these principles.
Now, if you read 3(1) and 3(2) carefully, I think everything is now narrowing down to 3(1) and 3(2).
Well.
If across the board, all specified goods, when it enters the local area, the liability to pay entry tax takes place on its entry in the local area. This is 3(1). 3(2), according to you, is an exception. If the goods having entered the local area is now subjected to a resale where VAT is paid by a registered dealer under the VAT, that dealer will go to the authorities, bring in documentary proof that yes, the act of resale had taken place. Now exempt me from payment of the tax. This is the way you are reading 3(2). What we are trying to ask is, if you read 3(1) carefully, subject to the other provisions of this act, means notwithstanding, taking note of all other provisions of the act, there shall be levied and collected. So the levy comes in, the liability comes in at this stage. And entry tax on entry of specified goods into any local area for consumption, use, or sale therein. So it uses consumption, use, or sale, also including sale.
My lord.
So this is in your favor. So the leviability of the entry tax, the liability of the entry tax is on the goods entering the local area, irrespective of the purpose, whether it is for consumption, it is for use or sale therein. So
Just giving example. Just giving example. That specified goods is there, which is exempted in the VAT Act.
Hmm.
There is no tax on the VAT Act.
Hmm.
Now, this is imported from outside,
But again, subjected to sale.
but subject to sale.
It may be.
It may be there.
Huh.
Now, in that case, entry tax is not exempted.
Hmm.
Because the goods must be taxable under VAT Act
Hmm.
and he must sell and they're liable to pay tax.
Hmm.
So at the stage
Hmm.
of entry,
Which are also taxable under
VAT
valuation,
Act.
because this will not be taxable under the VAT Act.
so where it
Hmm.
will be determined,
So now,
my lord.
difficulty is a language issue.
My lord, the constitution also will also.
I understand what we are having difficulty is a language.
My lord, the constitution bench also says 301, 30, they are not happily worded. They are not happily worded.
Hmm.
They have said,
But the difficulty is we cannot bring in unhappiness to a
but.
something not
but
happily
the lordship
worded.
has to give a meaning.
Huh.
Otherwise, what will happen, my lord? I'm just telling you an example. I bring the goods for sale.
Hmm.
For sale means resale.
Hmm.
Now I bring the goods. If say that no, if I bring the goods for sale, liability will not be there.
Hmm.
Then I keep it.
Hmm.
I consume
Mhm.
subsequently.
Ah.
I can keep it for 6 years.
Hmm.
And can make a sale.
No. This is where we have to distinguish the liability of a tax and the requirement to pay the tax.
That's why, my lord.
These are two separate concepts. Suppose in June of a given year, I have an income of say 1 crore. And subjected to income tax. The liability to pay income tax will arise at the moment I had the income of 1 crore
My-
in June of a given year. But I don't pay the tax unless I opt for TDS, the tax deduction at source. That is again, TDS is not a payment of tax.
Any advance payment, my lord.
TDS is only for the time being I'm
Is also a collection of taxes in advance.
it's a collection, but it's not a payment of tax, mind you.
But payment of
Payment
taxes,
of tax will take place at the end of the financial year when
Absolutely.
I'll submit my ITR.
I know.
Then there I'll declare that I'm liable to pay this much of income tax, including for that income made in June.
Absolutely.
Then the payment of tax comes. TDS is not payment. TDS is only safety
No,
measure. It's like a guarantee kind of a
No,
thing.
because like the advance tax we pay,
Advance tax.
like the advance tax, it is collected
Huh.
amount at the spot when you earn,
Ah,
pay immediately.
The department doesn't likes to pay it safe. You give us some money, deposit it here before we'll make
It
the
is
calculation.
Advance
Ah.
tax.
So now the liability occurs in June. Then in respect of that transaction, I am also entitled to certain exemptions, like those section 80, etc. Various kind of exemptions are there. At the time of filing the return, I claim that exemption.
Absolutely.
This is a case of exemption. The liability takes place in June. At the time of filing the return, I show my accounts that for this kind of transaction, I am entitled to that particular exemption granted under the Income Tax Act. Please exempt this much. So my income from 1 crore, now after the exemption, tax liable income may become 80 lakhs now. So I'll pay tax on 80 lakhs. 20 is exempted because of the exemption. This is exemption.
Now I will further adding more. Absolutely. If I'm not.
Tax is always something further is always
Well,
there.
I'm just not disturbing you. also. The LIC, etc., etc. deduction is there.
Huh.
Now,
Or you give donation to somebody,
Yeah,
all
but
those
this-
kind
the
of things
various
are there,
deductions are there.
various kind of.
interest from the bank, 50,000 or
Hmm.
whatever it is. Now, I submitting the return, I can claim the exemption of the whatever amount is there.
Mhm.
A provision is there that out of this will be deducted.
Sorry, last sentence.
Provision is there
Huh.
that for premium, for a single
Hmm.
amount extra,
Hmm.
this is the amount,
Hmm.
you will get reduction.
Hmm.
I don't make the payment of premium,
Don't make the payment of the.
premium.
Huh.
within that year.
Huh.
Now, there will no exemption.
Huh.
There will no exemption at all.
Hmm.
Similarly here, I bring the goods, become liable.
Hmm.
I don't sell the goods
No,
during that year.
no, this is your submission. We have understood very well. As I say, he pointed out that this is your submission. We are trying to examine it vis-a-vis section 3.1 and 3.2 now. One example goes of that income tax. Liability occurs in June of that given financial year. At the time of filing return, exemption is claimed.
My lord,
To some extent, it is exempted,
my lord,
and I paid the balance of the tax,
Right.
actual payment. So liability took place in June.
my lord.
Now here, under 3.1, if you read 3.1 minus 3.2, liability takes place when the specified goods enters the local area. To that extent, we are very clear and we are in complete agreement with you. Difficulty comes is what we are trying to ask you is 3.2. Now 3.2, notwithstanding anything contained in sub 1, sub 1 may bring in a liability, but as 3.2 is with a non-obstant clause, that notwithstanding whatever he may have produced, in spite of such a liability, and subject to production of documentary proof, no entry tax shall be levied. This is where we are having difficulty. So, no entry tax shall be levied will prevail, or 3.2 will prevail over 3.1.
Absolutely.
So when it prevails over 3.1, under 3.1 also, if the circumstance of 3.2 is satisfied, the document, etc., all those, no tax is levied. Means from the inception there was no tax. Once there was no inception from the inception, there was no tax. There was no liability. Although this will be determined a little retrospectively later on whether a sale had taken place or not taken place, but the liability is out. So can you construe this to be an exception?
Assuming for the argument's sake,
Huh.
assuming for the argument's sake, my whatever I'm submissions I make.
Because otherwise it could have been very easily provided. Provided that, or even if you go by notwithstanding also, in the event a registered dealer gives documentary proof that there was a resale of the goods and VAT paid, he will get an exemption of the liability. The word would not have been,
No, I for the argument's sake,
would not have been,
notwithstanding,
not saying, no entry tax shall be levied.
well, I take it for the
Huh.
argument's sake for the.
So no entry tax should be levied. This expression, can it be construed to be a,
Well, I've submitted,
to be an exemption?
well, I've submitted this. Assuming my view, whatever I'm convincing, is not accepted.
No,
And
no.
No, I'm. just
We are
arguing-
open minded. It's nothing like that we are no accepted, nothing like that we are accepting.
I've said for the argument's sake.
Huh.
Argument's sake, we come to a conclusion that 3.2, there is no levy at all,
Mhm.
and thereby the question of exemption does not arise. That if the goods which are sold inside the state and tax is paid, there is no levy at all.
GP also.
Then the act will have to be struck down further on the ground that you are not giving on, not only, it's not so that you are giving exemption. You are not levying anti-tax at all. Either exemption, you are levying the tax and then giving exemption, and the Supreme Court said you can give exemption, but subject to these conditions. Parallelism, all, additional burden, all of it. But if you say that you are not levying the entry tax at all,
By which paragraph of that Jindal still will be applicable?
well, the similar goods must be subject to tax.
Which paragraph?
Well,
Jindal?
304A, you'll also see Article 304A.
Constitution concern. No. If this is what we're trying to point out the other day, impose on goods imported from other states. Any tax to which similar goods manufactured or produced in that state are subjected. Suppose these goods resold are actually goods manufactured in this state, then 304A is squarely applicable. But all that 32 provides is none of the goods are manufactured in the state. Both the goods are imported to the local area. One of the goods is used for resale. Another of the goods is used for consumption or use. 32 distinguishes between the goods that is used for consumption or own use and goods that are used for resale. So therefore, 304A, which distinguishes between a goods entering from outside the state and the goods manufactured in the state, that distinction is not.
It is applicable.
It is applicable
If the goods are produced,
uh-huh.
coal.
Hmm.
I am bringing the coal from outside.
Hmm.
Coal is also manufactured, produced within Assam.
So, in other words, the challenge is not to 3.2, but to 3.1 itself.
Yes, I am not challenging 3.2. I am not challenging
Hmm.
3.2.
Hmm.
On the basis of 3.2.
So we don't go for the discussion of 3.2.
Well, I am on the basis of 3.2.
3.2, they are not living, that is their discretion.
No.
So that
They
for
cannot discuss.
3.2, goods covered by 3.2, there is no entry tax.
Well,
So once there is no entry tax,
Well, I
there is no question of 304A.
there will be.
This is where.
Well, I will come to that. Coal is there in Assam.
Hmm.
Coal is also coming from outside. Now, when that coal enters into a particular local area from Tinsukia, Dunduma to Barpeta,
Hmm.
entry tax is leviable.
Hmm.
But according to that is sold,
So,
that is sold within the state.
but entry tax is applicable, no doubt. But 304A is not applicable.
304 will be
Because
applicable.
304A is goods imported from other states.
I am submitting.
So, goods coming from Margherita and used in Borpeta is not a goods which is coming from other state.
No, Milord, it says if you lost it.
So 304 does not distinguish between pocket local areas within the state.
304A, what is saying, if you lost it, just permit me.
There is no reference to local area in 304A.
304A,
Huh.
impose on goods imported from other
Imported
states.
from other states.
For
So
the unit rate is a
for
tax.
304 to be made applicable, the goods has to cross the interstate border from outside the state.
That is correct, but
But 304 does not say that pocket local areas within the state, entry
No.
there too is also
but in case
covered.
the goods which are manufactured
Hmm.
within the state,
Hmm.
on that entry tax is not there,
Hmm.
then it will violate Article 304A.
Hmm.
Now, coal which is manufactured in the state,
Hmm.
within the state,
Hmm.
by virtue of 3.2, you are not imposing entry tax.
3.2.
by virtue of 3(2), you are not imposing entry tax because that is for resale and after entry tax is paid, the sales tax is paid.
No, for coal, whether it comes from Margherita or it comes from Bengal, across the board, there will be no entry tax if it is subjected to resale by virtue of 3(2). 3(2) does not distinguish that Margherita coal and outside
Well,
coal.
it-
Across the board,
It will be, well, if the lordship whatever is saying is accepted, then there is no levy at all.
no levy.
On resale, there is no levy at all.
No.
If on the resale, there is no levy,
Hmm.
then goods imported. I am bringing the goods from outside for the purpose of consumption.
Hmm.
And if another person within the state,
Hmm.
he is making resale and paying VAT.
Hmm.
He is not liable for entry tax. He is not liable for entry tax.
No. So when we base our argument on 304A vis-a-vis section 3(1) of the entry tax, one difference in the input parameter is 3(1) is on the basis of local area. 304A is on the basis of from one state to another, import from one state to another.
You're absolutely correct, madam.
So now, had 3(1) also been confined from one state to another, so meaning thereby, the entry tax will be on, say your example, coal, which is coming from Bengal. But the entry tax which is coming from Margherita has no entry tax. Then we'll have to examine it from the provisions of 304A. Because imported goods are subjected to tax, non-imported goods within the state are not subjected to it. But difficulty is 3(1), the relevant parameter is a local area. Local area means there may be several individual local areas within one given state. So if the goods are imported from one local area, manufactured in one local area, and it is entered into another local area, and the goods is manufactured in another state and also enters into the same local area, both will be subjected to entry tax. When both the imported goods as well as the goods entering one local area, one from another local area within state, both are subjected, 304A will not be applicable because 304 says that you could not have confined the levy on an import from one state to another, but no levy in case of brought in from one local area to the other or manufactured within the state.
How the, you're also correct, no? If the entry tax is there from one local area to another local area, and entry tax is also there from imported state. to
So
local area,
meaning thereby, examining it only from the point of view of Article 304A, there is also a levy of tax of this nature on a goods manufactured within the state.
Well, how? That's why I asked you a question, how?
Because
If you lordship is the interpretation.
Because if Borpeta is a local area and Margherita is another local area, moment the goods enters Borpeta, they'll be subjected to 3(1) tax.
But 3(2), then it will not be there.
That's why we are saying 3(2), if whether the goods is coming from local area Margherita to local area Borpeta or from outside the state to local area Borpeta, if it is by a registered dealer used for the purpose of resale, in both circumstances, there will be no levy. So again, there is no distinction between the goods imported from the other state and the goods imported from one local area to another local area, or in other words, manufactured in the state. So from 3.1 and 3.2 point of view, perhaps 304A is not applicable at all.
With due respect to philosophy. Subject to liability.
Because to be applicable, had there been no levy on the goods coming from Margherita to Borpeta, but levy in the goods coming from Bengal to Borpeta, 304A is squarely applicable. Immediately it calls for an interference.
As you also observed in the very beginning. What I was submitting that once the goods enters, the levy will be there. Once the goods enters into local area, there is a levy. Now from Margherita to Nalbari, when the goods enters, there is a levy.
No, as long as 3.2 is not there, there is a levy. But
We'll come to 3.2. No? So if the goods enters into the Margherita, from Margherita and Nalbari, then the levy is there. There is no dispute about it. To come out to 304A,
3.1 simpliciter levy is there.
levy will be there. Now we come to 3.2. Now, if 3.2 is there, then if those goods are sold and the goods are taxable and tax is payable on their own, there will be no levy.
No
That will
levy.
be applicable in respect of import as well as local area. Now, if it is said that from the very beginning, the levy is not there in 3.2, as Lossi said, from the very beginning, the levy will not be 3.1 will not come into apply at all. It will be 3.2 only. Then the levy is not there from the very beginning. The levy is not there when the goods are entering at all. At that stage itself, the entry is not there. Levy is not there. Now I am bringing the goods for consumption from outside. Assuming coal, I am bringing it for the purpose of use, consumption in my factory.
Understand, true.
Anti-tax is leviable. And the Margherita coal is entering to Nalbari for sale. There is no anti-tax. So 304A doesn't say.
No. Margherita Nalbari, there is entry tax.
Well,
Because it's a local area.
It is, if it is for sold in that local area, another local area, tax is not there. From Margherita to Nalbari. it
See,
enters-
Margherita coal also there is a, if it's a resale, there is no entry tax.
That's why I'm saying.
Bengal coal also, if
Resale,
it
there is no
is
entry
resale,
tax.
there is no entry tax.
So 304A it not saying that a particular purpose. It says that
It says, this is where we are putting the question again and again. 304A is that if the goods comes from Bengal into the local area of Borpeta, but goods coming from Margherita into the local area of
must be
Borpeta,
taxed.
or goods coming from this thing, there is no tax on the Margherita, but there is tax on Bengal. It will be hit by 304A.
I'm just again, repetition again, for the sake of. I am bringing the goods for consumption. Anti-tax is there.
So, Dr. Saraf, whole difficulty is what you know. There are 4 elements. One is element of bringing it from outside the state. And the other is element of bringing it from manufactured in the state, but bringing it from one local area to the other. 304 restriction is in respect of bringing it from another state. 304 restriction is not there when it is brought in from one local area to other local area, provided it is manufactured in that state. So one is state, one is local area. Number one. Other is, one is for consumption, one is for resale. These 4 elements, they are interplaying with each other in a different way. one way they can interplay with each other is if the goods are brought from Bengal, sold in Borpeta, it will be covered by 304A. If the goods are brought from Margherita, sold in Borpeta, it will not be covered by 304A because it is not imported from another state. If irrespective of whether the goods are brought from Bengal or brought from Borpeta, no tax is levied because they are subjected to a resale. There also, both are meeting the same situation. Suppose the goods are used for consumption. If the goods are brought in from Bengal to Borpeta, and the goods are brought in from Margherita to Borpeta, if the goods brought from Bengal would have been subjected to entry tax, but the goods from Margherita to Borpeta is not subjected to entry tax, it will be hit by 304A. Therefore, I refer that the basis of 304A is being imported from one state to the local state. But 3.1 basis is not bringing from one state to another. Basis is local area. Irrespective whether you bring it from Bengal or you bring it from Margherita, if you are entering the local area, it doesn't even, irrespective of where it is manufactured or whatever it is, you are subjected to entry tax. So both the local manufactured good and the imported goods are subjected to equal tax. So there is no violation of Article 304A.
Perhaps I've not been able to convey to you.
Or you want to think over it? Because I think ultimately we'll have to answer this question.
No, I'm trying to answer it.
It's not that we are trying to just. So now, to set aside 3.2.
I don't want.
No, forget that. Now to set aside 3.1. We will have to arrive at a conclusion that this is in conflict with 304A. That's the only way we will set aside. 304A, again we're repeating, import. One is imported, other is local. One is imported is taxed, local not taxed. It will go. But difficulty is 3.1 had the entry tax been not on the expression local area, but based on import from one state to other, straight away 3.1 will go. Because it will in conflict with 304A.
I'll make some shift.
But it being not interstate, but it being local area, that means goods manufactured in the state are also equally subjected. So, tax rate is similar goods manufactured, produced in that state are subject. So similar goods manufactured in this state, that Assam, is also subjected to the same tax by virtue of 3.1. So therefore, 3.1 does not violate the 304A. I think I should not ask you more. Please,
No,
submit.
it's better.
Otherwise, I am.
Unless feelings come, my lord, I will not be able to
No,
answer the question.
no. My purpose of putting question is so that I can get the answer.
No, absolutely.
Otherwise, the answer will be
No,
something
if your
different, and it
If
will.
lordship is not posing the questions to me, then I will not be able to answer it. And perhaps your lordship will take the view of whatever is coming, unless and until it comes from your lordship.
Definitely.
I cannot answer the.
So now I'll have a precise answer. I'll consider it.
So
If it is acceptable, we'll accept it.
Yes, so unless and until I know that what is going on in your lordship mind, Well, how I will meet the queries?
Difficulty is 3-1 had the expression
My lord,
local area not been there. Or local area would have been defined to the whole of the state of Assam. Then you are true. It will definitely violate 3048. Difficulty is local area is given a meaning, not the entire state, but fragmented areas within the state.
entire state, but
Hmm.
entire state has been divided in different local areas.
So, meaning thereby, the local manufactured good is enters from one local area and you are subjected. So the goods manufactured in the state are also subjected to
I'm
the
sorry,
tax.
this way, look.
Meaning the, or in other words, meaning thereby, this expression is not satisfying. But any tax to which similar goods manufactured produced in that state are subject.
My lord, I will try to, and I'm confident, my lord, that I will take your lordship to my side. That
Where
I try my-
we'll be very happy
I
to go
will
to
try
your
my
side, but,
best, and I'm
uh,
sure, my lord, once,
but I think this is the core thing we'll have to answer.
yes, there's no doubt about it. my lord. I have quoted your, what your lordship is.
We are making it easy for us to write our
My
judgment,
lord, I
so that we get the precise
I
answer from you.
I put the point that what is coming in your lordship's mind. And unless and until I can convince your lordship on this issue, that I cannot get the case through. Although there are other points also on which.
No, we'll go to all the points.
Now, this is the first point which I am taking.
We'll go definitely to all the
And
points.
first point I am taking.
And we have no dearth of time, don't we?
No, my lord, it has to be because my lord, question will also come. I'm just giving example. You'll also find in the act.
See, if we are required to decide an issue where there are constitutional judgment of the Supreme Court, refer to larger benches of the Supreme Court, then again refer to further larger bench of the Supreme Court, means how, since when this issue is now,
You'll also just.
and now you are asking us to take a call based on that. So
You'll also-
definitely we'll have to hear you.
You'll also see, once I'm going beyond, no, subsection 2, clause 3.
Hmm.
Subsection 2, clause 3.
No, we are leaving out 2 because you are challenging only 3-1.
No, 3-1, I'm challenging on the basis of 2. 2, if I fail to convince your lordship, then 3-1 on this ground at least will not be there. I must succeed in 2. Then only, my lord, the 3-1 will be, my lord, the validity will be under in question.
You are challenging 3-2,
See, I'm 3-1, I'm challenging on the basis of 3-2.
taking support of 3-2.
3-2. Now you'll also see subclause 3.
3-3.
3. 3-2-3,
3-2-3. huh.
clause 3. Now you'll also find here also no anti-tax will be levied subject to production of documentary proof if 3 million
If specified goods are imported in local
to
area,
local area in the course of import from outside the territory of India. So if the goods are coming from outside the country in course of import, no anti-tax will be levied. Now, this is because of what? This is because of the restriction imposed in Article 286 of the Constitution of India. Two 86(1). Now, 286(1) puts a restriction on 2 things. One, import from outside the country. Secondly, sale and purchase taking place outside the state. The state cannot levy any tax. The legislature has taken care of import. But so far as the interstate movement, that is a sale which is taking place outside the state,
So you are challenging from the point of Article 286 then?
This I'll come because that if you are exempting import,
Hmm.
on what basis? Article 286. So you were very much aware that because of Article 286, you cannot impose in tax. Now, if you cannot impose any tax on import because of Article 286, how you can impose a tax on the purchase?
So timing, we do away with 304A. Now we
Well,
let us concentrate on 286.
This is facet, that assuming this is there, then 286 is there, then there is another provision by.
So we have to go issue by issue.
Well, I will come to, I'm just, because your lordship will be rising at 3:30. And today, my lord, I find that the network is not good, my lord.
Which network?
The
Network is good.
network from my side to your lordship,
Network is very good, don't worry.
it is little, my lord, disturbance
No,
is
no.
going, my lord.
No disturbance.
My lord, so this is, I'm saying, my lord, that this
See,
is,
Dr. Saraf, ultimately, when we are hearing you, we also keep it in our mind that we have to write on this
my
one.
lord, I've heard,
So-
I have argued so many cases before lordship. And 10, 12 days SEBI case, 15 anti-dumping duty, so many cases I've argued. I know, my lord, that asking the questions, queries and all those things and giving the answers, it helps in, I think, coming to the conclusion while writing judgment. Final conclusion, your lordship will have to take. And that can be only when all the things are clarified against me or against the state. That is a different thing
You have to
altogether.
write something.
That is
Write
different thing.
something with a reason.
That is a different thing altogether.
Hmm.
But unless until the queries and all these things come, it will not be possible for me also to read the mind of your lordship and to explain that what is coming in your lordship mind. Many times it happens, my lord, the judges, they don't pose questions. And it will become very difficult for the council because he doesn't know that what is going on in the lordship's mind. And he's arguing something else.
See, Dr. Saraf, there are two ways I can handle this situation. One, uninterruptedly, you go on saying anything you feel like saying. I'll also keep note of what you are saying and also take note of how I am viewing what you are saying.
My lord, that type of argument, if you're also not asking, it will become too boring.
See,
An
and
argument,
ultimately, your argument on 304A, I would have delivered a judgment the way I'm putting you the
because
question.
that there is no necessary argument. I can give a written submission and then you'll also decide.
No, that means, no. I deliver my judgment in the line of the question I'm asking you.
That's why I'm saying, my lord.
Tomorrow, you'll be little, you'll have a thought in your mind that had this question been posed to me, I had an answer.
My lord,
But just because the no question was
my lord,
posed,
the first part which your lordship said,
the order went that
the
way.
first part which your lordship said that your lordship will hear and I can argue whatever I want to argue.
That would have been the
No,
consequence.
then there is no need of arguing. I can give my whatever I have to argue in written submission. But unless and until the queries comes
So,
and I have to answer it, there is no news of the actual hearing is not there.
so this is not a connectivity disturbance. This is
Connecting-
just
Connectivity says, my lord, I have not been able to convey
this
properly.
is just a way trying to just
I have
understand
not
what
been able
you
to
say.
convey to your lordship properly that, or I can say that meet the queries which have been raised by your lordship. My lord, what I am submitting, my lord, before lordship again the next day, my lord, 3:30 your lordship writing. My lord, 304A,
Hmm.
there are two entries, 52 and 54. Entry tax 52 and
Okay,
sales
entry
tax,
tax,
54.
where do you get in entry tax act?
Schedule, my lord, Constitution of India 7 schedule, list 2.
No, your entry means entry in which
The
statute?
power on which the entry tax is enacted is entry 52 of the list 2.
Entry 52 list 2. Constitution. No. List 2, entry 52. Entry 52 of list 2. There is no entry 52 of list 2. I think it was entry 52 omitted by Constitution 101st Amendment.
2017
Okay.
Constitution Amendment,
Ah.
it is gone. In the footnote, you'll also find.
Footnote is there.
Entry of the goods in local area for consumption use is still there.
Hmm.
Now 54 also you'll also see in the bottom itself footnote.
Hmm. Taxes on sale of petroleum crude, high-speed diesel motor spirit.
No, that is, you'll also have to see the footnote below. Because that also has been amended.
No, 55 had been omitted.
54
54
amended,
is there.
54 substituted.
54 is,
Tax on sale or purchase of goods other than the newspapers or entry other than the goods specified entry 92A. Sale.
taxes on sale or purchase of goods other than newspapers subject to the provisions of.
Article entry in 92A.
So 54 is sale, 52 is entry.
Now, these are two separate legislations conferring power on the state to levy tax. Now here, we are, in fact, the state legislature is mixing up entry 54 with entry 52. Now 52 is about entry tax. 304A speaks of the same tax. The same tax. Now, because you have paid the sales tax, the levy will not be there because of 3.2. Because you have paid the sales tax, the levy will not be there from the very beginning. If it is interpreted in that manner, that it is not exemption, the levy will not be very beginning. That means for entry 54, to achieve the purpose of entry 54, you are giving an exemption under entry 52. You cannot equate the entry tax with the sales tax. You cannot say that since he has paid the sales tax, entry tax is exempted. Because if that is so, then locally manufactured goods have not suffered entry tax.
No. State always, it's their discretion, what tax to levy, what not tax not to levy.
There's no dispute about it.
So, but once you levy a tax, that should be subject to satisfaction of the provisions of the Constitution. You should have that power. But not to levy a tax,
There's no dispute.
you did not trace to any power.
But there's no dispute.
So
There's-
now, state feels that in respect of those goods where we are getting sales tax, we will not impose an entry tax, no levy. So this is what 302
that-
is a non-levy provision.
in my humble submission, that is directly hit by Article 304A.
How?
Because you are saying that those who are paying sales tax, we don't levy the entry tax. Now, sales tax is on the sale of the goods. Entry tax is on entry of the goods. 304A says that any tax which you are imposing on the imported goods, you must impose on the locally manufactured goods also. Now, in the locally manufactured goods, you have said that once you pay the sales tax, entry tax is not there.
This is what we are saying.
So you cannot.
Understand, whatever good is imported, moment that good is paying the sales tax, 3.2 is attracted, no levy of entry tax.
I am making a distinction.
So,
I am making a distinction.
so the local manufactured good as well as the imported good, both are now subject
Well,
to the sale tax.
This tax, it doesn't say the tax in 304A, it doesn't depend on that somebody has made a sale or exemption. No. The question is that the entry tax which is levied, if 3032 is interpreted to mean from the very beginning, the levy is not there. If the sale is made, say making a sale is after the taxable event has taken place, according to me. If that is not interpreted in that manner, then from the very beginning, you are making an exemption in respect of the goods which are sold and in respect of the goods which are for the purpose of consumption. Whereas entry 52 does not levy, different entries are not there. It is tax on entry of goods.
No. 304E, we will examine only what tax is levied. not what tax is not levied. The restriction prohibition in 304 is you cannot levy a tax which is imported from another state if the same tax is not levied
On the good local.
on the good locally manufactured. Now, we test this from the point of view of 3.2. 3.2, what happens? Whether the goods is locally made or it is imported, it is subjected to the VAT. So, both imported goods as well local goods are subject to VAT. For no levy, we are not required to do anything. If the imported good is also subjected to VAT, no levy of entry tax on that when it enters the local area. The locally manufactured good which is subject to VAT, if that good also enters the local area, locally manufactured, there also there is no entry tax. So here is a case of non-levy on
Both the goods.
both the goods. Now, where levy is there in 3.1. 3.1 levy says if the goods enter a local area, there will be entry tax. These goods, it may be imported, it may be locally manufactured. Both category are, the goods is equally levied, meaning thereby whatever tax is levied on the imported goods, same tax is also levied on the local manufactured goods. So 304A is not attracted because 304A will be attracted only when the imported goods are subjected to a levy, but similar local manufactured good is not subjected. But 3.1 subjects both local as well as imported to the same tax. This is what we have read from the beginning, what we are trying to ask you.
Speaks of entry of the goods for use, consumption or sale therein. It speaks of use, consumption or sale therein.
Only when 286, if you read, it is outside or in. Not 286. We are reading, sorry, we are reading entry 52 as it stood earlier. Taxes on entry of goods into a local area for consumption. So Constitution recognizes a local area. Now we read 304A, imported from one state to the other. So the constitutional provision itself distinguishes between a local area and the import. 3.1 is related to only a local area. Had 3.1 levied a tax on any import of good inside the state, straight away 304A will be applicable and that will be unsustainable. In one stroke, we can set aside that one. But as 3.1 is not on the basis of a local area, but it is on 3.1 is on the basis of local area, not import from one state to another, where both locally manufactured as well as imported outside are equally subject to the levy of that tax. There is no infringement of 304A because the local similar goods manufactured in the state and similar goods imported, both are equally subjected to the levy of tax. And 304 will prohibit it only when the imported one is subjected, but the local one is not
Not
subjected. This is where we are,
We may do one thing, no?
it's interesting.
Well,
I think it needs
We are also some time will have to
some further examination will be
thought
required.
over the entire matters, find out some judgment for your lordship.
Because otherwise, if the court is asked to strike down 3-1 on the basis of 304A, we'll also have to equate the expression local area in 3-1 with date of import from one state to another in 304A. Only when we can say it is one and the same thing, meaning thereby the local manufactured good is not taxed, imported goods taxed, only then we can interfere with 3-1 on the basis of 304A.
Perhaps I will try on the next day to place some judgments on the issue.
Definitely, something maybe.
And
And tax laws are always very peculiar. Any kind of interpretation may be there
if it would have been so clear and something, but our existence itself will be a stake. So the better, my lord, it is more complicated and complicated so that we can exist. If it becomes very clear and lucid and all those things, we will difficulty, my lord. So the better it is more complicated and complicated so that the lawyers fraternity can survive. So also we keep on next date, my lord, so that I will also,
When you are,
when you will also come in, my lord.
it is Thursday and Tuesday. Man, 8 Thursday or next Tuesday, I don't know. Or Saturday is also open this time if you want.
Saturday, yes, sir.
Okay, sir, would you like to come on Saturday?
Saturday, my lord.
You'd like to come?
I have no problem, my lord. Subject, when your lordship can come, why I should not come?
You don't know for
My lord, we are always up to a lordship, my lord.
with what kind of an open mind will come, you know,
No, no,
will
no,
come.
all-
That is true.
My lord, everything is dependent on lordship's convenience, my lord.
Thursday for 9. Thursday would like to continue.
Thursday,
or
my lord, I can do it, but there are 2 series are there, so I don't know, my lord.
Then next Tuesday. Then next Tuesday. In the meantime, I'll try to read that complete 1000 pages also. Did you, Mr. Chaudhary, you read that one? You read the whole-
Last time I tried to, but after going 150 pages, lordship,
You
I
felt
got confused. Again, I have to read it again.
After 150 pages, what happened?
Lordship, I got confused, lordship. Last time when it was heard before, Justice, Chief Justice Bopana and A.K. Viswani.
After reading 150 pages, confused.
Then lordship, whatever senior counsel has stated, I noted it nicely, then I could make it out. lordship.
You have some matter?
For this series only, for item number 20, we are there, lordship, it should not be segregated. We'll let the
20
scene,
should not be segregated.
will
What
stick
is
to the
item 20?
Arunachal.
We are not segregating anything.
Okay.
We'll hear everyone.
My lord, if you can do, because there is one matter in Shillong in the morning, I will do it virtually
Oh, virtually.
on Tuesday. So
Because nowadays you can't come back from Shillong.
no, I'm not going to Shillong, I'm doing virtually. There's no question at all, Shillong virtually.
Shillong nowadays, situation is such. It takes about, if you go in a leisurely way, it takes 1.5 hours to reach Shillong.
By
But it
11:30,
takes another more than 1.5 hours to reach the place inside Shillong.
by 11:30, it will be over. So I will come before that, but subject to the only little adjustment.
Definitely. মানে লিখিব নালাগে আকৌ we'll keep it in mind that it will be called at 2 o'clock.
Lordship may not record it because
Uh-huh.
if I come before that, then I will start at the time.
No, we are not recording. We'll keep it in mind.
My lord.
Our order, same order. Oh, Dr. Ashok Saraf learns in a council for the petitioner dealers makes further submission on the unsustainability of section 3(1) of the Assam Entry Tax Act. Assam Entry Tax Act 2008. Inasmuch as it would be hit by the provisions of Article 304A of the Constitution of India. To the extent that there cannot be a discrimination between the specified goods being imported from outside the state and being subjected to a tax where a similar goods manufactured within the state is not subjected to such tax. Remains inconclusive, this one.